Okay, great. So the meeting is now being recorded. And we'll be posting the slides, the maps, and the recording and notes on the discussion to the website following this meeting. And as I mentioned at the beginning, Tom is available for any tech support questions you have, so you can send him a direct message in the chat. And closed captioning is another option for this meeting. Here's the where that's located at the bottom of your Zoom screen. Okay, any questions about the ground rules? Okay, well, again, thanks again for joining. It's great to have 48 folks on this call, and we will now move into the substance of our presentations. So here is a overview, a very high level overview of, oops, sorry. Yep, no, that is, yep. Of the systems, the two systems, the Eel River, or the Eel River Basin and the Russian River Basin, just at a very high level here. There we go. So we're going to start off with Ryan will be speaking about water rights in the Russian River Basin, and then Erica will be speaking about water rights in the Eel River Basin. And jumping over to this map, which focuses just on the Russian River. So we circulated a 2-page brief that Ryan prepared before the meeting. Did our best to send that to everyone who had registered, and we also sent it to all the Water Rights and Water Management Working Group members. If you didn't get a copy of that, you could send a direct message in the chat to Tom or an email to him, and he can get that off to you. But Ryan's going to be speaking from this map. So Ryan, I'll turn it over to you.
Thanks very much, Jim. So good morning, everyone. As Jim indicated earlier, I'm Ryan Becerra, and I'm outside water right counsel for Sonoma Water. I represent other water agencies across the state. Yuba County Water Agency is another, City of Santa Cruz, multiple entities in the American River Basin. So anyway, this is what I do for a living. And let me tell you my goals, at least for today's meeting, and then what it would seem to me might be future meetings along this line. And Matt Clifford's comment earlier gets at that. The goal today is to scope out in pretty general terms, you know, in the Russian River Basin, what are the different water sources, how do different water rights apply to them, and how might changes of Potter Valley project affect those rights. I certainly understand there is some discussion to be had about the question of what becomes of the Potter Valley's water rights. So Matt was correct that the briefing paper assumes that some water would continue to come through the Potter Valley project into the Russian Basin, but I understand that's a subject to be discussed, and that involves a whole nother complex of water right issues that are not addressed in the briefing paper that we frankly probably need another briefing paper to talk about those. So in any case, what I plan to do today is to talk about the water supplies and water rights in the Russian in sort of two different segments of this discussion. The first bit will be about the different sources and relevant locations in the Russian Basin. And then what I would plan to do is stop at that point and take any questions about that subject. And then once we work through those subjects, we would then switch to the actual water rights and how changes the Potter Valley project might affect them. So with that, I'm going to speak almost entirely from this map. We certainly can jump to the briefing paper to drill down on any given statements in it if people like, but I think it's probably pretty helpful for people to see the map as we work through the various sources and water rights. So with that, I'll start in on the sources and supplies. So I suspect, as many of you know, frankly, better than I do, the Russian River Basin is more or less divided into segments, and there are different sources of water available in the different segments. And the two primary ones are the Upper Russian River, which you can see in green, which is effectively from the confluence of the East and West Forks down to where the Dry Creek confluence. And then below the Dry Creek confluence is the lower Russian River. And the reason that division is particularly important is that, of course, Sonoma Water operates Lake Sonoma on Dry Creek as storage facility, and so is can augment flows in both Dry Creek and the lower Russian in a way that is not possible in the upper Russian. The upper Russian, as you can see, basically has three sources of water available to it. You've got natural flows deriving from precipitation. So, for example, as you can see on the map, upstream of the confluence of the East and West Forks, the West Fork does not have anything but natural flows in it. The East Fork, of course, has natural flows, and then also has Potter Valley imports that are not consumed within Potter Valley Irrigation District. That water makes its way down into Lake Mendocino, where it can become stored water. So the upper Russian River, of course, has stored water releases from Lake Mendocino, in addition to natural flows, and in addition to Potter Valley Project imports that are bypassed and not stored in Lake Mendocino. So that green section of the river there, the upper Russian, basically has three sources of water available to it. Natural flows, Potter Valley imports that are bypassed through Lake Mendocino and not stored, so what we might call run of the river imports, and then stored water releases out of Lake Mendocino. Sonoma Water, as the local sponsor of the Lake Mendocino project, operates the dam as for water supply purposes, at least. And those water supply purposes include not only consumptive, but Sonoma's water right permits are subject to minimum stream flow requirements. So there are times when Sonoma Water is releasing stored water to maintain minimum flows. So that's the hydrologic condition essentially running in the upper Russian River system. Once you get down to the confluence with Dry Creek, then Sonoma Water's regulation of Dry Creek flows out of Lake Sonoma ties into both water supply and minimum flows again. In that, Sonoma has the right to divert stored water releases from Lake Sonoma at its water supply facilities. There you see the Wohler and Mirabel water supply diversion, which then water diverted there goes into Sonoma Water's transmission system. But Sonoma's ability to augment, in particular, lower Russian River flows from releases from Lake Sonoma is constrained by a variety of factors, including federal biological opinion requirements. So it is not the case that Sonoma is capable of moving flows in the lower river up and down however it sees fit. So the flows from the upper Russian into the lower Russian remain, a very significant component of supply in the lower Russian, notwithstanding the storage releases out of Lake Sonoma. And so all of these different sources are associated with different kinds of water rights. There are overlapping water right issues, as the briefing paper indicates, but effectively there are different types of water rights associated with the three different sources of water. Natural flows have one water right regime essentially associated with them. The Potter Valley imports, which for purposes of California water right purposes fit in the box of abandoned water, meaning that they are abandoned more in general by the water right holder PG&E when PG&E ceases generating hydroelectricity at the Potter Valley Project powerhouse. The water then flows out of the powerhouse into the system, and it becomes subject to other people's water rights currently. So that's the second source of water in the upper Russian. The third is the release of stored water from Lake Mendocino, which, because it's stored, is generally subject to the water rights of Sonoma Water, and then I'm gonna refer to this entity as the Russian River Flood Control District. Its name is longer than that, and I saw Beth Salamone and Jeannie Zalesi on the list, and they know that issue as well as I do. But essentially, there are two water rights that apply to stored water, and so under California water law, those two entities control the stored water to the extent of the water supplies. So when that water is released from Lake Mendocino storage, it is subject to a different water right regime than either the natural flows or the Potter Valley project abandoned water. And again, those are the three primary water sources in the Upper Russian. And once you reach the Lower Russian, you add in releases from Lake Sonoma, which have their own water right regime. So at that point, I'll stop and see if we have questions about the different sources and where they're located. And I know there are Sonoma Water staff here who probably may be more capable of answering technical questions than I am on these subjects. So I'll happily defer to them if they'd like to talk about this too. So I'll stop there.
Great, thanks, Ryan. So we'll go to hands raised, and I see Supervisor McGorty has one. Go ahead.
Sure. So the abandoned water that comes out of the Potter Valley project, what is technically the water right for that water?
Water like that, that is imported to a watershed and then effectively released by the water right holder, is subject to appropriative water rights. And so you get two different sets of water rights that can apply to that. The water rights between 1905, when that water began being released to the system, and 1949, which is when the water rights at Lake Sonoma take effect, they may have an appropriative right to that water on a run-of-the-river basis. And then the second set of rights is those 1949 rights to store and use water from Lake Mendocino. To the extent that water is stored in the lake, they become subject to Sonoma Water and Russian River Flood Control's 1949 water right permits.
Okay. Thanks, Ryan. Next hand was from Chris Watt with Russian River Flood Control, and then Reggie Collins.
Good morning. Thanks, Ryan. I didn't hear you mention the 10,000 acre foot reservation on the Lake Mendocino. Is that something you're lumping in to one of the other categories, or maybe it
talk about that
complicates
in the second bit of this.
Perfect. Thank you.
Sure.
Great. Thanks for the question, Chris. And next, Reggie Collins with Caltrop.
Yeah, just more of a comment and I guess a follow-up question with Ryan, and appreciate Ryan's thinking on this. You've been really helpful on getting a lot of folks up to speed on water rights surrounding the project. So really appreciate your work on this. I think it's important to note that that may right there that you had in your description of the abandoned water from the foreign water supply, meaning that an appropriative water right from that, and again, you're going to talk to different lawyers and get different analysis. Once that abandoned water is chosen not to be released by the entity importing that foreign water, meaning if PG&E decides not to import it, there is no effective water right associated with water that is no longer in the stream. I mean, you only have a water right if the person, meaning PG&E, decides to put that water in stream. Of course, there's a lot of nuance to that. You can read many a law review article on the subject, but that's an important distinction that should be mentioned.
Yeah, and I can add a little to that. There is a whole line of California water law built around the concept of foreign water. We move water around this state a lot. Water ends up in places it would not have under a state of nature. And when the entity that does the importing has a lot of discretion to decide to do things differently. And so that will become a major subject of discussion here is if another entity comes to hold the PVP water rights, what will that entity decide to do about it? They're going back to the 1930s. It's been clear under California water right law that the importing agency, water right holder, can make changes that may have adverse effects on people who come to rely on the foreign water. That is a very important element of California water law and will be relevant to this discussion going forward. For today's purposes, I was trying to scope out the general rules, and essentially the question that Reggie's comment ties back in with what Matt Clifford said at the beginning. And to my mind, that's a next discussion to be had about what the rules are around potential changes in imports of foreign water to the Russian system.
Okay, thanks, Ryan, and thanks for the question, Reggie. I don't see any more hands. So Ryan, why don't you continue with part 2?
Okay, so part 2, so scrolling through the different water sources, natural flows, PVP water that is not stored, and then stored water. We'll break those down into 3 pieces and what different water rights apply to those. So natural flows is generally the easiest, as you might imagine, or at least conceptually, if not in practice. And so as to natural flows, riparian right holders, who in general are landowners along a river and potentially its underflow, have a priority right to use those natural flows on their adjacent lands for reasonable purposes on those adjacent lands. So in general, that's agriculture and potentially domestic use. A city does not have cannot hold a riparian right to serve its residents because that entity would be serving other people's lands. But in general, a riparian right on riparian lands has a priority over appropriators to natural flow, and then the appropriators among themselves have first in time, first in right priorities generally to those natural flows. So that the green area there, the Upper Russian River, riparian landowners along the Upper Russian River, would in general have a priority right to natural flows. Now, that does not include water that is imported to the system through the Potter Valley project. So a riparian landowner does not have a priority or any right to use imported PVP water. That water is subject to appropriations. It's not strictly, in this case, in first in time, first in right order, because the PVP water began being imported in 1905. So an appropriator who came before 1905 would not have intended to consume PVP water since it didn't exist. So between 1905 and the 1949 rights at Lake Mendocino, that class of water right holders would have some probably priority to PVP imports to the extent they're imported and on the pattern they are imported, not stored water. And that right would continue all the way through the system out to the ocean. So potentially pretty complex sets of appropriative rights to PVP imports on a run-of-the-river basis. You then get to the question Chris Watt raised, which is in 1949, our Sonoma Water and Russian River Flood Control hold 1949 priority permits to store water in Lake Mendocino. And then in general, under California law, the entity that does the storing has the exclusive right to use or to contract for use of its stored water. So in general, in California, if you own the reservoir, then someone else needs a contract with you in order to use your stored water. In the case of Sonoma Water here, it's a little different. When Sonoma Water obtained its permit for Lake Mendocino, the State Water Board inserted a term that we call the 10,000 acre foot reservation. And what that states is that parties in the Sonoma County portion of the Russian River Valley can obtain water right permits to use collectively up to 10,000 acre feet of the stored water at Lake Mendocino, even though they come after Sonoma Water's 1949 permit. That class of water right holders, however, only can go up to 10,000 acre feet. As best we can tell, much of that reservation has been consumed, but it is unclear whether it has been fully exhausted. So in effect, the State Water Board gave that class of appropriators a priority to up to 10,000 acre feet of water stored in Lake Mendocino. So that class of entities doesn't necessarily have to have a contract with Sonoma Water to access that increment of storage. And then as I said earlier, Sonoma Water has in its water right permit for Lake Mendocino minimum stream flow requirements that they must release stored water to meet if natural flows are not sufficient. There are many complications associated with that, but we saw that situation occur in 2021 and 2022 when Sonoma Water was needing to release stored water because there was so little natural flow in the system. So that's the basics of the water rights. I know that's complicated and I'm happy to take questions.
All right, we pause here again for some more questions. Please raise hand if you'd like to ask any questions or clarify anything. Okay, great. Thanks for the hands. And yeah, please, when you speak, say your name and your affiliation. Beth, please go ahead.
Salamone, Russian River Flood Control District. Thank you very much, Ryan. That's been great to bring everybody up to speed, basically, on the water rights. I know the answer to this, but I think it would be helpful to this group to understand a little bit more about the communication and understanding of the water right holders. So how do water right holders know when stored water is being released and it may not be their source of water? How do those who have access to the 10,000 reserve pool know? How is that tracked? So what is the communication or lack of communication, as it may be, between the regulators, the operators, and the water right holders? Because I think it's really important that people understand the cloud of confusion there. Thank you.
I would say at this point, and Sonoma Water staff may want to clarify this, I don't know that it is clear when those different conditions happen and what the breakpoints are. There was some of that under the Water Board's emergency drought curtailment regulations in 2021. That became, pretty clear. The Water Board was going to communicate out when Lake Mendocino was not meeting the projected storage curve. But I think in the general run of years, it is not clear at this point how those communications exist, and it becomes pretty complicated because, of course, the map we're seeing is somewhat of a simplification by necessity, but you have various tributaries coming in at various places on the Russian River, and so that may be a different question for different reaches of the river depending on tributary inflows.
Great, Thanks, Ryan. Next question is from David Tabor. Go ahead.
Hi. First, to build on your answer, during the curtailment, each and every water right holder in the Upper Russian River was told whether they were under curtailment or not based on some model. And I'm sure it's a lovely model. There are 1,800 water rights holders, and you had to check, I think it was every month on a website. But that wasn't my question. This is regarding just the nature of riparian rights. You had mentioned that it was mainly agriculture and the lands adjacent to the river. Does that apply to mutual water companies that are owned? The mutual water companies are owned by the landowners, but it's more than one landowner.
In general, under California law, right, mutual water companies are treated as riparians to the extent they are serving uses of the lands within the company. They are treated as a collection of riparians rather than as a separate corporate entity.
Okay, even though there's in fact only one diversion, but implicitly under the law, it's actually several water right holders.
Correct. And you can get into all kinds of complications there if some lands within the mutual water company are no longer adjacent to the stream. Things can get very complicated, but in general, mutual water companies are recognized as a collection of riparians exercising their individual riparian rights.
Okay, thank you, Ryan. Next hand is from Michael Hardy with Kearns and West.
Hi, Ryan. Haven't
Hi,
talked to you for a while. Just a question. Will it be important to address this question of exhaustion of the 10,000 acre-foot reservation as part of the Russian River Forum's path toward achieving its objectives? Or not?
I would think so, that it would be useful to understand that, because that is an important class of water rights. Those people who hold those water rights have access to stored water in a way that other water right holders do not. And the access to stored water, it obviously becomes more and more critical as natural and other flows drop.
Thanks.
Okay, looking for, not seeing any other hands. Ryan, are you through the material that you're going to present, or is there, would you like to, more to come? Okay.
No, that's what I've got. Happy to take further questions, but that's my presentation.
Okay. Great, well, thanks. Well, we'll have some more time after Erica's presentation to circle back for additional questions, but now we will turn over to Erica, who will be speaking about the Eel Basin, which we have here on the map. And Erica has some slides, which I will switch to now.
Thank you, Jim. Good morning, everybody. As Jim said earlier, my name is Erica Costa. I'm an attorney at Berkey Williams, and we represent the Round Valley Indian Tribes. We are their general counsel, but more specifically in my role today, I will be here as their water counsel, talking about a high-level overview of federal reserved Indian water rights. I'll talk a little bit about the Round Valley Indian Tribes water rights, and then do a similar sort of high-level overview of our understanding of the current water rights holders and landscape in the Eel River Basin. So again, just to note, I'm speaking in the capacity of my representation of the Round Valley Indian Tribes today, and that map that you all should have access to of the Eel River Basin. I should note that the practical purposes of that map is to show the reservation in relation to the project. I just want to note that there are many other, tribal nations within the Eel River, Russian River, and Russian River basins. Those aren't included on that map, and that's simply because my focus today is on Round Valley, and as I said, their relation to the location of the project. Thanks, Jim, for pulling that up. So as you can see, the project is is south of the reservation. And just kind of a funny quick story as I started working on this, I remember the first time looking at a map and thinking, well, hold on, the dam is south of the reservation. Why are we talking about water south of the reservation and moving this way and that? And as you all know, the Eel River moves north, and its headwaters are south of the reservation, but it's a north flowing Eel River that flows out of the mouth down south of Eureka. So just for those who are thinking about that and thinking about a map, you know, the river does flow this way and flows through the reservation and sets the reservation's boundaries. So just in terms of orienting yourself with, as I said, the location of the reservation and the project and things like that. So Jim, if you want to go ahead and go to the next slide, I'm going to jump in on the Federal Reserve water rights piece. Again, this is going to be pretty high level. I have the fun task of sort of synthesizing Supreme Court precedent beginning in 1908 down into hopefully something that's digestible for folks. I'm sure there will be lots of questions. So my plan is to briefly go through this reserved water rights doctrine and talk a little bit about the Round Valley tribes water rights, and then pause for questions before I kind of do a global overview of non-Indian water rights in the eel. So breaking it up for folks who have questions in that way. So the Federal Reserve water rights, so that's the concept that essentially establishment of an Indian reservation recognizes a tribe's right not only to that reservation land, but also the resources on that land, including sufficient water to fulfill the purposes of the reservation. So as is implied in their name, federal Indian Reserve water rights are predicated on federal law and aren't dependent on state substantive law. So I think the information that you see in Ryan's briefing paper, for example, on the difference between California's kind of hybrid mixed state where there's appropriative, but there's also riparian water rights. Those are important to know within the context of that, but it's also important to know that those don't apply to Indian water rights. There's some similarities, but there's also huge differences when we're talking about Federal Reserve water rights. So as I said, important to keep in mind, but there's going to be some important distinctions too. So this, the doctrine of implied reservation of water rights for Indian tribes comes from the Winters decision, Supreme Court decision in 1908, which said, as I said earlier, it's the doctrine that the creation of an Indian reservation, the setting aside of an Indian reservation, impliedly reserves water rights to the tribe or the tribes. In this case, we have Round Valley Indian tribes, which are a confederation of tribes, multiple tribes occupying that territory, sufficient water rights to carry out the purposes for which that reservation was set aside. And we can talk a little bit more about purposes in terms of the Round Valley Indian Reservation, but the general concept in most instances is the idea that a reservation is set aside as a homeland for Native people. And so the need for sufficient water rights to support a homeland for the tribes who are on that reservation. And I think that what's important to note too is that while most tribes' rights arise under this implied reservation doctrine, there's also for many tribes an Aboriginal right as well, and we can get into that a little bit more. But essentially, the idea is that tribes are continuing a practice that they have had and long before a reservation was set aside. So that comes into play a little bit too as we start thinking about priority dates and things like that. I don't think Ryan touched on this too much in his presentation, but I know it's in his briefing paper as well on the different priority dates and things like that. So in general, for Indian reserved water rights, the priority date of the tribe's water rights is oftentimes time immemorial, so since time began. And in those instances, as I said, it's when the reservation is set aside and continues to protect and preserve a practice or right that the tribes have had long before the arrival of Europeans and that right is continued and protected. So for example, if you have a tribe like Round Valley, who it was a fishing tribe long before the federal government created the reservation, then you have a right that's being protected that is, as you know, has since been exercised since time began. But for a great many other tribes, particularly those who have reservations are set aside to set up essentially an agrarian or agricultural practice that many tribes didn't have before, their right would start on, at the latest, the date the Indian reservation was created. So you essentially have this new use moving forward. So the latest priority date would be when the date that the reservation was created. So those are two priority dates we often see regarding federal reserved water rights. A couple other just quick kind of big picture things to know about the characteristics of tribal water rights. They're not geographically limited to those streams that either move through or border the reservation, but can apply to the water basins and flows that are, you know, upstream from or off the reservation that impact the river that the tribes do rely on. So, you know, tributaries or streams up north of those water bodies that border or go through the reservation. Those are important as well. We've talked about first in time, first in right. We've also talked about putting water to beneficial use and those sorts of things. So those don't, this is where a key distinction, I think, between state water rights and federal reserved rights is that approach to the use it or lose it, you know, put your water rights to beneficial use or you risk losing them approach to appropriative water rights doesn't apply to federal reserved water rights. So for example, if you had an Indian reservation that was set up in, you know, the 1800s that didn't start putting their water to use until the late 1900s under a reserved water right, they would still have a priority date that's superior to, you know, non-Indian, water rights holders that hold a state law priority date acquired after that, 1865, when the reservation was established. So I think, again, those are some pretty high level characteristics of how federally reserved Indian water rights work in practice. For many tribes, the Round Valley included, these rights, tribes have these rights, they're established under federal law, but they haven't necessarily been adjudicated yet or confirmed by a court. So oftentimes they haven't been quantified, you know, to X amount of exactly what those rights are. So there's still some additional information and characteristics, I think, of Indian water rights that are really specific to each tribe. So maybe I can get in a little bit more and we can dig in a little bit of the characteristics of the Round Valley tribes rights as well. And again, be ready to answer some questions I'm sure folks will have after that. Jim, you want to go to the next slide? I can talk about Round Valley real quick. Thank you. So as I said, the tribes have unadjudicated federally reserved water and fishing rights in the eel that derived from the creation of their reservation in 1858. So a brief history of the reservation. I think that something that's really important whenever I talk about Round Valley, I think it's particularly, you know, when we're having a discussion with their neighbors, it's really important to know the history of the reservation. The reservation was established first in 1858 with the entire Nome Colt Valley, so the whole Covelo Valley essentially was set aside as a reservation for what they call for Indian purposes, so for the purposes of Native folks living there. And then I think that what's also important here is, you know, we have Native tribes. Round Valley is a confederation of tribes, meaning there are multiple tribes living together under one tribal government. And we have Native folks who were living in the valley since time immemorial, but the Round Valley also has a really tortured history of, in the 1860s, other tribes were essentially rounded up and relocated at gunpoint by a cavalry of U.S. soldiers and had to walk from the Chico area through the mountains to Round Valley. It's a distance of more than 100 miles. And less than 500 people set out on the journey, and about 250, so about half of them, made it safely to Round Valley. So as I said, the reservation and the history of the reservation has a really, really tortured history, but I think that that's really important here as we think about how these tribes came together to create a government and thrive in the valley despite this history. So after that forced removal in 1873, Congress reduced Congress and then following executive order, reduced the southern boundary of the reservation, but then expanded the northern and eastern boundary of the reservation too, so that by 1873, the reservation boundaries were set by the Eel River on three sides. You had the main stem of the Eel River as the western boundary, the North Fork of the Eel River as the northern boundary, and then the Middle Fork as the eastern boundary. And specifically in that 1873 act extending the reservation boundary, the federal government reserved for the tribes the privilege of fishing in those streams. That's language that's included in the statute. So I think that, you know, and before I talked about federally reserved water rights, and those are implied rights. So the idea is that, of course, when you set aside a reservation, there has to be sufficient resources to live on that reservation. So implied with that is a reservation of water rights. But I think here we have that as our baseline. But in addition, we have this confirmation of how important those fishery practices were to the tribes, and that they're specifically called out and reserved in these executive orders moving forward. Let's see. So just in terms of sort of what that means, that the reservation is set by, the boundaries are set by the river, and then those rights to fish are preserved and protected. What that means is that it entitles the Round Valley Indian tribes to minimum flows in the Eel River. The main, as I said, the main stem, the North and the Middle Fork, and its tributaries to support a healthy fishery, meaning that without a healthy fishery, the tribes can't exercise, you know, their privilege and right of fishing. So, as I said, included in that is the minimum flows to support that fishery. And I touched on this earlier too about the priority date of the tribe's water and fishing rights. Included in that, this goes back to that statute of including the verbiage and language of privilege of fishing in said stream, that's sort of calling out an Aboriginal use of the Eel River that the tribes had, you know, long before the federal government. So that would be an Aboriginal use and a time immemorial priority date. But at the latest, it would be the date that the reservation was set aside in 1858, or one could argue maybe 1873 when Congress enlarged it. So I think I want to pause there. I don't want to get too much into other details in case I'm sure there's a lot of questions about what I just said. But again, trying to kind of keep this high level so we don't get too deep into and confusion and things like that. So I'm going to pause there and see if there are any questions about Federal Reserve water rights or the tribe's water and fishing rights that I can answer.
Great, thanks, Erica. So yeah, we'll go to hands. Again, when you speak, say your full name and your affiliation. Start with Dave Tabor. Go ahead.
Hi, Dave Tabor, Palomino Lakes Mutual Water Company. Just a question. The notion of the Aboriginal and time immemorial fishing rights. We obviously don't have the Aboriginal environmental conditions overall. Is there any sort of, has there been any legal precedent when it comes to pollution and climate change affecting the fishing rights? I mean, if you have a fishing right, but there's no fish there anymore, not such a useful thing.
Yeah, that's a good question. I think let me make sure actually I'm understanding your question correctly. So I think what I hear you asking is, there are probably many stressors on a water system, and have those sort of, the ones that are not necessarily out of human control, but those that are result of climate change and those sorts of things, have those been discussed or been part of the analysis that courts have looked at in determining federal Indian water rights? Is that the question?
Yes, generally speaking, yeah. It's just that the notion of change that has happened since, let's say, the 1870s. There have been a lot of environmental changes, such as modern agriculture and that kind of thing, that obviously affects the quality of the water. And so the question is, is that taken into consideration when looking at a fishing right?
Yeah, so I think that, I mean, it's definitely part of the big picture here, right? That if the idea is that the tribes need a minimum flow in a river to support a healthy fishery, you have to look at all the impacts, or all the things that are impacting the river, and what needs to be addressed in terms of bringing it back to a healthy and restored fishery. So that's, I think climate change and those pieces are definitely a big part of it. I should say too that, we're kind of starting to talk about like courts and analysis and things like that. There of course has been a lot of litigation around Indian water rights generally for decades, since 1908, when the Winters Doctrine was made by the Supreme Court. But I should say too that a lot of times, and we're getting a little bit more into sort of like litigation versus claims and those sorts of things, a lot of these things tend to get hashed out in water rights settlements. So I think that there's been a huge trend recently in recognizing that litigation is expensive. It takes a really long time. There's a lot of uncertainty, especially in terms of water rights and the length of time that those can take, negotiating those and how long that can take. So a lot of these claims have been resolved through settlement. We have a lot of Indian water rights settlements. And so those pieces that you raised, David, can come up often of how do we address some of these bigger picture climate change issues, and how do we, what's in our control and how can we improve those and their impact on the fishery. So that's definitely a big piece that gets talked about during these settlements discussions.
Well, thanks for the question, Dave, and thanks, Erica, for that. And next hand is from Glenn Spain. Glenn, please go ahead.
Can you hear me?
Yes.
Erica, there are other federal water right reserves, and if you could speak to water right reserves for ESA listed species, there are several in the eel, and also water rights reserves under federal law and the Clean Water Act.
Sure, and that's a good point. I think my focus today is on Indian reserved water rights, but the federal government, and I should note too that there are other tribes in the Eel River and Russian River Basin. There are other tribes who may have a similar analysis. This is really fact specific. For example, our office represents the Wiyot tribe as well, and they have similar issues regarding use of the river, time immemorial, and reservation establishment and things like that. So, but that's an aside. To your question, Glenn, I think that there are, as I said earlier, there are Indian reserved water rights, but there are also just federal government reserved water rights too. And those often come with, say the federal government has a park, and there's a reservation of federal land that comes with water rights as well too. So there are also other federal reserved water rights on the eel as well that are separate and apart from tribes, and ones that are held in trust for tribes. So I can't speak necessarily to the details of, you mentioned ESA and clean water and those sorts of things, but maybe Ryan too, if you want to, I see you raise your hand, if you want to add a little bit to that.
And one follow-up, there's also wild and scenic river requirements as well.
Right.
Go ahead, Ryan.
Thanks. Yeah, just to add a little to Erica's statements about reserve rights. It's absolutely the case that there can be reserve rights for other purposes. The gist of the Federal Reserve Right doctrine is that the federal government has reserved some of its land for a specific purpose, and that the federal government necessarily reserves the volume of water necessary to serve those lands. So, for example, I represented a party in the Antelope Valley groundwater basin down near Los Angeles. And in that case, the federal government asserted a reserved groundwater right to support Edwards Air Force Base. And the ultimate settlement of that adjudication recognized a federal reserve right to serve that land, which is the Edwards Air Force Base. The second point is that the issue of federal reserve right for fishery purposes can become pretty intertwined with statutory terms under the Endangered Species Act. In particular, there's a 2019 Federal Court of Appeal decision concerning tribal reserve rights and the Endangered Species Act that applies to the Klamath River. That's a case called Bailey versus United States. And it's a very useful decision for understanding how reserve rights and ESA interact. And if you have an interest in reading a court decision, that one might be pretty useful background for people interested in this issue on the eel.
Thanks, Ryan, and thanks, Glenn, for the question. Next, we have Dennis Murphy. Please, your name, Dennis, and your affiliation.
Yeah, Dennis Murphy, Sonoma Ag. I had a question about, have the tribal governments you've worked with formed an opinion about interbasin transfer of water ultimately being part of the solution or not in their thinking?
So when you say solution, do you mean like a resolution of the tribe's claims, or what do you mean by solution?
Meaning that the outcome of whatever comes out of this forum and future forums may include the continuation of some interbasin transfers out of the eel into the Russian, and have the tribal governments formed an opinion on that yet?
I see. So the Round Valley Indian tribes are a member of the Two Basin Solution Partnership. They've been working closely with Jared Huffman's process for a long time and working closely with the other partners as well. So the tribe's goal throughout this process has been to work with their neighbors and work with their partners and see if it is possible to restore the Eel River to a healthy, vibrant fishery, while also gaining some, I think, not predictability, but security with regards to their water rights, but also security on the Russian River side as well. Is there an opportunity here to resolve some of the tribe's outstanding water rights claims in a way that, as I said, it sort of lends to reliability for both the Russian River and the Eel River side. So certainly it's part of the tribe's thinking here, and is that's the tribes are definitely, open to continuing those discussions. I think that one part, what I've always thought of for the tribes as co-equal goals are certainly restored Eel River. That's incredibly important, a restored, healthy, vibrant Eel River, but also some clarity and resolution with regards to their water rights claims. And I think that this whole process presents an opportunity for that. And so the tribes are, as I said, interested and willing to keep thinking about that as part of this process.
And thank you.
So, okay, and I know Erica has some more material to present. Any other questions at this point? Okay. Thanks for those questions. And Erica, next slide.
Yeah, please.
There we go. Great. There we go.
So I should just add the caveat here that my main focus is obviously on the sort of federal rights piece, and the tribe's water rights piece in particular, but of course we can't think about those in a vacuum. They interact with the state water rights pieces and things like that too. So we've done some pretty high level just research on the lay of the land in the Eel River Basin specifically, on state-based water rights. So this is just the results of some research that I've done using the State Water Board's database that's available to anybody. Just to, as I said, kind of get the lay of the land of what the state of the water rights are in the Eel River. So you have pre-1914 and post-1914 water rights and we looked at, I looked at Mendocino Lake and Humboldt County, given the location of the project. And this is sort of, as I said, like a high level overview of these different rights. And I should note too that some of these rights are statements of diversion, some are permitted, some are licensed, some are revoked, some are inactive. This is a really, when it says, for example, 751 rights, that's, there are many different types of rights that fall under that. But as I said, this is just kind of a really, 30,000 foot level look at what things look like in the Eel River. And it ranges greatly in terms of the largest diverters. PG&E is obviously one of the largest diverters, especially in the upper Eel and Lake and Mendocino. The U.S. government too, we have Forest Service, municipalities, ranchers. There's also domestic livestock and cannabis rights as well, water companies. So there's a wide array of different water uses on the Eel. And I should note too that as helpful as this database is, which it is extremely helpful, once you start trying to narrow down by like water system, that's where things can get a little wonky. For example, I tried to narrow down these searches beyond the Eel River watershed and look at the main stem, and that becomes a lot harder because not all of the rights are sort of categorized in such a detailed way. So I didn't even want to try and put those numbers up because I didn't feel like it was an accurate reflection of what might be the case. So we have, as I said, we have a general sense of the rights on the Eel and how those may, these are rights that may too be impacted by changes to the project, and with the future of PG&E and the project still, not quite known exactly what it will be at the end of the day. So like I said, this is just a really high level overview. Happy to try and answer some questions, but again, this is kind of lay of the land, and happy to hear if folks have had some use of the database too and found little tricks for refining searches and things like that. But it is extremely helpful to have information like this to be able to pull up and see what's going on, be able to pull up applications and those sorts of things. So yeah, I'll pause there and see if folks have questions.
Great, thanks, Erica. Yeah, so again, please raise hands if you'd like to ask a question or share a comment. Right, Mike Hardy, please go ahead.
And again, thanks, Erica. This is helpful. And again, just to try and flesh this out. The tribe's right is, and I don't want to get this wrong, primarily to support the fishing, as well as I suspect other activities. So I don't want to limit it to that. I'm curious, is the tribe also a diverter? Or I mean, as well as other diversion uses in addition to fishing and maybe other uses the tribe has?
Yeah, that's a great question. I've kind of focused on the water and fishing rights today in terms of the water rights in the focus of of non-consumptive water rights. So that's water rights in a river that's needed to support fish. But there are also claims for consumptive water rights.
Okay.
And those are for focusing on, as you said, diversions to support activity on the reservation, diversions of water to support activities on the reservation, agriculture, and those sorts of things. So that is another piece of the kind of big picture water and fishing rights claims. We've really tried to focus here on the impact of fish and the flows in the river. But yeah, that is a piece of the tribe's water rights that we'll want to continue to think about. I do know that on the state, well, the tribe has some state-based water rights too, but that's separate and apart. But yeah, so a diversion and those sorts of things for consumptive water use on the reservation is a piece of the big picture water rights process for the tribe. So thank you for that question.
Thanks. Also, I just want to introduce Mike Hardy, who just asked that question. Mike is one of our principals here at Kearns and West, and he will be facilitating discussions of the water rights working group going forward. So during this working group, we look forward to working with Mike. He's worked for decades on complex water and water rights issues. Any other hands, questions? Supervisor Crandall, please go ahead.
Thank you. Thank you for the presentation as well. I completely and utterly empathize with Round Valley. I understand the right to water. My children are descendants and related to elders and ancestors from Round Valley, and I think that at one time or another, we as tribes didn't even essentially think of water as something you owned. We just accessed it, but here we are. So again, thank you for this synopsis of this subject. I say that from my side of being a tribal member from Robinson, but as a county representative, I'm glad to see that we're talking about the rights in Lake County as well. As just to emphasize, point of emphasis, from the mountain, from the snowpack, it runs and initiates in Lake County. So I just wanted to emphasize that. There's nothing else I really have to add to this. And thanks again for the presentation.
Thank you.
Yeah, thank you, Supervisor Crandall. Next, Reggie Collins with Caltrout.
I have I guess I have a comment and then I have a question for, I think, Ryan and Erica. The first is that, in looking at these water rights bundles associated with the project, it can get really confusing really quickly. There's a bunch of good memos done by groups interested in this. I think one follow-up will be for Ryan and Sonoma Water and Caltrout and Brown Valley to think about, putting together, our collective memos on the subjects to really outline something that, could be viewed as an objective take on water rights as possible, given the nuance on people doing the analysis. And so that's one thought moving forward that I think will be helpful. I also think it's really important to understand that the pre-1914 right associated, or that PG&E currently owns, if transferred to an entity that wanted to divert water, would fulfill the modeling need for Lake Mendocino and the Russian River water use, especially in PVID during the winter months alone. And so while it is a very complicated bundle, I think focusing on the amount of water associated with that pre-1914 right, the ease at which you can essentially email the state water board and change that timing of diversion to winter flows, and the amount being able to move during that winter time period is modeled to show that a continued diversion is possible should we agree on a project type moving forward. So while it's incredibly complicated, I think that people should focus in on looking at pre-1914 right and the ability to switch that right. My question after that little diatribe is on public trust, and knowing that any continued diversion associated with that may be subject to public trust litigation. And so this is not really technically a water rights question, but the concept being that the state owns in trust water associated with every river in California. No one owns any water. They may have a right to use that water, I think, as Ryan probably discussed in the beginning of his presentation. And so the public trust is essentially the idea that the state needs to protect that, and moving large amounts of water from one river to another ultimately pulls in public trust considerations, including human health and safety, fish and wildlife, recreation, a number of concerns that needs to be balanced. And so I was wondering if Ryan or Erica would have thought about that issue, or would like to discuss it here for the group to consider.
Sure, I can talk about that a little bit. So to me, at a conceptual level, you kind of have different interests. You have environmental interests, which in both basins include very sensitive fish species. You have consumptive interests, which include a lot of different things, municipal and industrial, the subset of municipal that is public health and safety, agricultural. So, there's consumptive interests, there's recreational interests. And I don't think this has ever been, so you have under the California Constitution, this basic concept that water rights in California are subject to reasonable use. I don't think it has ever been determined how that California concept applies to a federal reserved right. As far as I know, we've never had the fun of litigating that issue anywhere in the state. So Reggie, the concept of public trust, I kind of, it's largely an issue of environmental interests, to my mind, with reasonable use then being somewhat broader than that. And so I think there's a lot of legal concepts bouncing around that kind of affect the same interests. So, what is necessary for under the ESA for any listed species overlaps to a large degree, in my mind, with what a public trust interest might be. And then that overlaps, I think, at least in the Eel Basin, with the kind of fishery interests that Erica was describing. So public trust is an important legal concept. I kind of view it as an interest that is covered by a variety of legal concepts. And, hopefully we don't find out any more about the parameters of the public trust doctrine through court litigation here than we absolutely need to. So I
agree with that.
I tend to start by thinking of it in terms of, well, what are the interests at play? And then those different interests fit into a variety of legal boxes that you could argue about, but hopefully you don't have to find out the full scope of those legal boxes before you get to a solution.
Thanks, Ryan. Erica, would you like to add anything to that, or Reggie, do you have any follow-ups? Erica, go ahead.
No, go ahead. I don't have anything to add. Thanks, Ryan.
Okay.
Nope, I think that's good. Yeah, I agree. I think it's just a concept that should be floating out there, considering, when we look at solutions for this project. That's something that if we all don't get along in this room, that could be a long process that would at least give Ryan and I job security for a long time.
Great. Well, we've got about 15 minutes left here. Are there any further questions?
Sorry, this is looking for the hand raise button. This is Matt. Let's try to limit it in the committee. For Erica, you've talked about kind of like what the substance of the tribal claims are, to water rights, et cetera. I wonder if you could say at least a little bit about, you describe these as unadjudicated. I assume they're not quantified, right? And so what the process by which the tribe would kind of establish or quantify the water rights would normally be. My understanding is a fairly lengthy process. I assume it involves, I'd like to know more about that.
Sure, and I kind of touched on this a little bit ago too. The sort of traditional way of quantifying a water right would be through the federal court system, and having a federal court decree that quantifies a water right. But I think for a lot of tribes nationally, but also I think from the tribe's perspective too. There's a lot of upside to considering a settlement outside of quantification litigation. As I said, nationally, there's been an increase in negotiated settlements, just given the disadvantages of state, general stream adjudication processes. They're time consuming, they're extremely expensive. They don't come with funding. That's a huge piece for the tribes. Tribes here is often a big piece of water rights settlements includes a waiver of the tribe's claims against the United States. And with that waiver, oftentimes comes financial support from the United States and economic assistance to develop and continue to preserve water resources. So that's something that doesn't often come out of litigation. No funding for water development projects or restoration. So again, big picture, each settlement is really specific to the needs and conditions of each party, but that's something that's attractive in terms of the flexibility within a settlement of a quantification being a critical piece, but also that economic assistance and funds for tribes being a key piece of those settlements too. So that's kind of the two, I would say, main options with which those quantifications and processes happen. You have adjudication or you have settlement.
Thanks, that's helpful. And it's a settlement to which like the state and federal governments are parties, correct?
Yeah, so again, it kind of ranges from settlement to settlement, but oftentimes you have tribes, you have core participants obviously would be tribes in the federal government. But you will have states participating, you have private individuals participating. So it really ranges in terms of the folks who participate in those processes.
Thanks.
Thanks for that question, Matt. Any further questions? All right, Beth, please go ahead.
Thank you. So I'm going to go back to my question to Ryan and his presentation, and I'm going to sort of answer it a little bit more because I think it's really important. And I think Erica's points made it stronger in my mind how important it is for us to understand. When we're talking about appropriative water rights and riparian water rights, I'm not discussing tribal water rights in this comment because I'm not as familiar with them. But there's a fog around the understanding, and that is what the actual water rights are. Erica showed us, it's very difficult to search and find all of the water rights that are available or that are issued, and there are various times of use and things like that. There's restrictions on each water right that make it even more difficult to categorize them and get a full picture. Then there is that's considering the face value and the terms of that water right. Then you look at the actual reported usage on those water rights. Erica, I didn't even bother to ask if you had, if you did a dive into reported usage on the water rights in the EEL, because I figured from your comments that was, I extrapolated the answer there. And I've done it on the Russian side, and it's very, very difficult. So even just looking at what the water rights are, their face value in terms, and how much water right holders are using of their water rights, how they are implementing and exercising those water rights, that is complex. It's very complex and difficult to track. There's no one really tracking that with any great clarity. Then we talk about the understanding both from the, well, more than both, but from the water right holders' perspective, again, talking about their source of water, when it is available, understanding the terms of their water right, understanding how to properly report their use, which is very complicated for those of you familiar with that, and SB 88, for example. There's the constraint on the operators trying to use this information. In this case, in the Russian, that would be mostly Sonoma Water, Army Corps, and in the EEL, I would assume PG&E and others, because there isn't a clear picture. And then also the regulators themselves, who, such as the State Water Board, who are in essence in place to protect, I don't like to use that word, but to to administer, protect the water rights system as it is. And without the information easy at hand, it is difficult for them to, for example, identify when junior water right holders are diverting water outside of their water right that is in essence a senior water right holder's allocation. So when we're talking about this in the scheme of the Russian River Water Forum, the future of the Trans-Basin diversion, this is all information that really needs to be parsed out and communication enhanced, because water right holders are going to be impacted and they have no idea. And the operators and the regulators and the planners, everyone moving forward to work on a trans-basin diversion, future, we don't necessarily know the full picture either. So I don't have an answer. I just want to make sure that most of us already understand that, but I know we have a lot of folks in here that are learning about this. So this is something complex that every conversation when we talk about water rights as water leaders, this is part of that conversation. Who are the people that need to be in this conversation? Who are these water right holders? Thank you.
Thanks for that, Beth. Mike, over to you.
Beth, just briefly, those of you who practice in this area know that California has not had a significant number of adjudications recently. And I think you're correct. I have mediated a number of water rights settlements, and some of our team worked on the effort to negotiate a settlement in the Fresno River. We weren't able to get to a settlement despite the good efforts of quite a few parties and interest in that approach. The board is, I haven't tracked the latest status of it. Maybe some of you practice more with the board or aware of the status, but what I'm leading to is a significant lift is necessary to provide the kind of information that you're talking about, that in my experience and probably in the experience of many of you, in order to provide a foundation for the kind of conversations that people need to have. And so that's definitely going to be a task. What the exact shape of it is, I don't have a sense of at this point, but I appreciate the point you're making. I will say it's been my experience that the state board staff have been very willing to help, but there's no perfect single system. And as I was listening to you, I was wondering if there are two parts to this. The first is the nature of the water rights and understanding the rights, but is there also an operational clarity set of questions as well? And I don't know the answer to that, but I'm listening for what's going to be important to all of you.
Great. Thanks, Mike. Not seeing any further hands, that may be a good note to end on, just in terms of how sort of what work to be done in this working group going into the coming months. Are there any further questions? Otherwise, I can go to the wrap-up slides. Great. Well, thank you again so much to our presenters, Ryan and Erica, and to all of you for joining. We had 60 people on the call at the peak. So great to have such a good, strong group here. And thank you for all the questions. Just to talk about a couple of next steps. So we are in the process of scheduling the working group meetings for the water supply and fisheries meeting, as well as for the first working group meeting of that group, working group, as well as the first meeting of this working group, the water rights and water management group. Tom Fisher from our team will send out that doodle poll again for the water rights and water management meeting. And if you could, for those of you who are on the working group, if you could reply to that, and we will get that meeting calendared. We're also related to that, we'll be convening a technical briefing on water resiliency, following up on input that we received at the planning group meetings. And so looking for that probably in July. And the other two working groups that are part of the Russian River Water Forum process, governance and economics and finance, will have just very quick overviews at the July 13th planning group meetings, and then moving forward with some more in-depth work on those probably later in the summer. And just to wrap up here, just in the last couple of minutes, we will be sharing the notes from these discussions along with all the materials that we shared. And in the next couple of weeks, we'll begin working with Mike to put together the agenda for the first water rights and water management working group meeting. Some of the themes that we captured today were on the focus on the water rights associated with the Potter Valley project and how those related issues and legal interpretations about how those may change under various future scenarios. Understanding all the different interests in play, further understanding of potential public trust considerations, other reserved rights in the eel, digging deeper into the full collection of tribal rights in both basins, understanding more about the information and monitoring challenges that Beth raised just now and that Mike elaborated on, and also communicating the various issues related to water rights to all the water users and to the communities more general in both basins. So looking forward to those discussions going forward. We have just a couple more minutes in case anyone has any final questions, including about anything procedural. Okay. Well, thank you again, everyone, for joining, and again to our presenters, and we will follow up with more information soon. Thank you again.
Thank you
Thanks,
very much.
everyone.